Hi, James. How are you doing this morning?
Doing well, Megan. How about yourself?
Doing great also. Thanks so much for being willing to meet with me on a Sunday morning. I know that it's not ideal, but my client's very excited to go ahead and get this deal ready and to help represent Nightlight the best that he can to his abilities.
Absolutely. And I appreciate your time meeting with me as well this Sunday. There's a lot of exciting developments going on, I think, on both our sides. And so I spoke with my client's CEO yesterday, and he's very excited about this agreement in general. He and Will have a great relationship, and he's excited about the prospects, that he has going on in his business, and also that Will has going on in his social media presence. I also, just want to thank you for the detailed review of the agreement. It is a relatively new area of law, and so there's a lot to consider there on top of just the normal considerations for our clients. And I also know you're waiting on my responses to your red lines. And so being cognizant of that and kind of the time constraints we have today, I'd like to run through some of my clients' priorities, and then you are free to, add something or help me reprioritize, and we can kind of go from there. Does that sound good?
Great. Sounds great, yes.
Great. And so the first kind of top priority is really just the compensation structure overall, touching really on the bonus structure, which I'm sure the YouTube component will come into play. Then also the retainer. And then that'll start touch on some of the different scope and Will's obligations under the contract. And then we'd like to go into the termination clauses. I think both our clients are very concerned about their brand, so want to be careful there. And then lastly, the assignment provisions. And so those are kind of our top three priorities. There's a few other things we can hit if we have time, but do those all sound good to you?
Yeah, I think those sound really great. And, especially just kind of as a overarching premise going into this negotiation, as you mentioned, there's some new developments coming up, and we're so excited to hear that Nightlight has this opportunity for the Houston location coming up very soon, especially, during the height of the baseball season. So I think that really understanding what Will's involvement is going to look like and what Nightlight's hopes are for his involvement is going to be a great way to really frame the negotiation and address all these concerns, such as his obligations on social media, appearances, and also compensation, as you mentioned.
Absolutely, it all sounds fantastic. And so just to kind of dive into the bonus structure portion of it, similarly, we know there are some developments from Will's social media presence. The world is a funny place, and ironically, YouTube is now kind of coming up, and he's gaining presence there. So if you could just help me just give a kind of an update on the status of that and how you are thinking about that affecting the structure of the monthly bonus.
Definitely. Will, he originally, as you know, was kind of inactive on YouTube, but he recently just went ahead and posted a video for fun just showing some baseball tricks. And it looks like it's going viral, which is great to hear. And so that's something he's potentially thinking about, really getting back into that space. I know that, when we were looking at the monthly bonus in Exhibit C, but also in Exhibit A, we kind of crossed off the posting requirements for that YouTube section. So I think that what we'd be able to do is, potentially only commit to like a once every other month YouTube post while he's still kind of learning the ropes for that. But he really sees his main endorsement of the Nightlight products is going to be, mainly on the Facebook, Twitter, TikTok, Instagram, social media platforms. As for a payment for a post, just doing some research on what like a nano influencer on a platform such as YouTube is going to be creating per post, just because YouTube kind of has, a larger time commitment per video versus just simply posting a picture on Instagram. It's going to be more of a $200 per video rate, which would be integrated into that monthly bonus structure.
Okay. And so just a couple things I wanted to note on that. All of that sounds fairly reasonable to me. So we'll be looking at, $200 per post once every other month. And so from my client's perspective and the instructions I have, he's less concerned necessarily about the details there and more concerned about the total spend. And so, looking at that, we can go through the details and kind of, iron that out. I know the other thing he is concerned about is that total spend, and then just the kind of having some control over it. And so from that perspective, in the bonus structure, our concerns were really around Will's ability to basically post unlimited amounts of videos.
Gotcha.
Or not, or videos, or just any sort of social media posts. So looking at, we can post as needed. And so like your proposals from the YouTube perspective seem reasonable. I can take some of those numbers back to my client, but I think the bigger concern here is really going to be my client having some control both over the content going out. So, just having some sort of approval process. I know in the notice provision in 7.3a, you're looking for 48-hour notice. I think we have some room to give there, but I know my client's going to want some control. And then also just if we are going above those numbers, potentially, if he's really starting to like YouTube, committing to one, maybe two every month, and if he starts growing, that would be something my client would be interested in, but we would want some way to approve that or some kind of mutual agreement there, just if we are going to go above those numbers, that my client has some visibility to control his budget.
Definitely. I think one thing we can do to kind of solve that second point you were just bringing up of solving the amount of posts and whatnot, especially as hopefully Will's YouTube following really grows, is mostly on YouTube, they're going to be announcing, this is an sponsored video right here. And so I think Will's anticipation is to kind of have other videos where perhaps Nightlight isn't the main focus of that video. And so what we could do is we can limit it at least to the minimum once every other month, or the maximum it would be once every other month. And then if for some reason, we're approaching that budget constraint that your client was mentioning, then we can go ahead and have a discussion with Will and say, hey, we've loved the videos you're putting out, but maybe that's a point where we'll take YouTube off the table and really focus in on some of the other areas for Nightlight. But does that sound like a potential solution for that second point that you were bringing up?
That sounds reasonable. I think we would still want, it really goes back to the ultimate spend. And so YouTube is one component of that, obviously, but there is still spend there for TikTok, Facebook, Instagram, all that stuff. And so it's kind of the one thing we do want the flexibility. So having just some open-ended, slightly more open-ended terms, like if it goes above this amount, maybe there's just a sit down, they discuss, they take maybe YouTube off the table for a month, they increase in other places. I think that all sounds very reasonable. So, but we need to have some level of control over and just kind of a mutual agreement there.
Definitely. I think that the bonus structure we can be flexible with as long as we're able to really come to a solidified agreement on that annual retainer, which we're going to be discussing moving forward. I do want to just address that first concern that you kind of brought up with the 7.3, the scope of kind of where Nightlight wants to have a say of pre-approval processes, I'm assuming, before Will goes ahead and puts the post up. And just so you understand our rationale for that, Will loves to post kind of on the fly. It's a very organic translation and communication with his followers when he's doing such a thing. And so that's really where we came up with the 48-hour notice period on that note. I think something that we can do, and I was speaking to Will about it just because he's very eager to learn and represent Nightlight in the best way possible, is that we can have a sit down between Will and Jackson, or whoever Nightlight's head of marketing is going to be, and kind of do a couple hours of social media training. That way Will can really learn what Nightlight's true expectations are, the do's and don'ts of social media, and that way they can really be on the same page moving forward. Does that sound something that your client would agree to?
And so I was speaking with my client as well, and we're on similar pages. He understands, he follows Will, he sees his social media, and that is a big part of it. Instagram stories, stuff, it's on the fly. It should feel organic and natural, and we don't really want to limit Will there. However, my client really wants to balance that against his brand. Nightlight really has this, unique brand, hashtag be kind. We're very protective of that. And honestly, we feel like that is something that has drawn Will to us as well. He's a great representative of that, but we still want to just be a little cautious there. So I think from speaking with my client, he will be comfortable with Will eventually having some more freedom. I think similar to what you're proposing, having some sort of initial training, maybe some different categories of posts, sort of pre-approved, if you will. So if he does, something happens, he pitches a no-hitter, he can post something very quickly and not have to worry about approval process. But we would like some sort of courting period, if you will, or for maybe the first 2 months or so, there is a little bit more approval process while we're kind of feeling each other, really just, developing this relationship and making sure we're on the same page. And I think we can be a little bit more flexible on the approval terms. We had required 5 days prior written notice. We can look at walking those back a little bit for those first months. Maybe something like, 3 days with email confirmation. So as opposed to just notice, an email confirmation will suffice as opposed to going through the whole written notice procedure through the contract.
Yeah, I think that sounds like something that my client's going to be able to agree to. I like the idea. We can do like a 2-month trial run per se, where we'll go ahead and get this pre-approval process. And then after that time, we can see really what the development looks like. And if he's kind of just doing things on the own and he's had no obstacles in the process, that's where Will can go ahead and get some more freedom with the post and being able to do it on the fly per se. I do just kind of want to note one thing, that way Nightlight isn't expecting something. If Will were to hopefully pitch a no-hitter, that type of language of kind of his performance in a game, we're going to want to refrain from in social media posts, because that's where we really get into the pay-per-play space, which is still ineligible by the NCAA versus just the name, image, and likeness endorsement abilities.
Absolutely. It was just a top of the head example of just trying to get there's different categories of posts, but I appreciate that.
Definitely. Just wanted to give the heads up on that. Great. So I think we're kind of in agreement then with at least social media posts going out. And, I think that bonus structure that we were talking about is really going to be tied into the retainer, if we can kind of switch over to that conversation. And, the main questions we have really come into play with this new Houston development is we need to understand, what is Nightlight's expectations of Will being able to partake in promoting the new Houston development, and just what their hopes and goals are for Will.
And so this is exciting developments for Nightlight. It's a little bit, I would say, sooner than we expected, but we did have some plans to start expanding the local kind of Texas area, other big kind of college towns. And we would love to have some access to Will. There is a big Baylor following there, and having him be able to appear during some of the initial kind of like openings, the grand openings, some different events there, maybe at the Astros Stadium and stuff, so we can really start getting our brand out there. And so we are looking to get some more commitment from Will, so we know we have access during that time period, especially during the openings. Once we kind of get through that sort of, again, opening, it'll probably just be more of a general, between Waco and Houston, potentially other areas as well. And that's where I think we'll just go more into the kind of like the general travel requirements. But I do know specifically for this summer, which is kind of the general time frame that we're looking to open the Houston location, we would like some more firm commitments for days for being there for grand openings and signing autographs and just being an ambassador to our brand.
Definitely. And I can totally understand why Nightlight would want solidified dates for the opening. I'm not sure if there is a solid date in place or an expected date of the opening yet, but I just want Nightlight to be cognizant of the fact that, we kind of saw that it was early summer when we were looking at the emails exchanges. That really is the heightened part of Will's baseball season representing Baylor. And so he's going to have a lot of obligations during that season to Baylor and to the team, and representing himself in games and practices, which, as we know, when he's doing that, he's not able to partake in NIL activities. And so just so you're aware of kind of the calendar of his obligations and potential obligations, the last regular game of Baylor's season this year is going to be May 21st, but then we're kicking it right off into the postseason. So May 25th to May 29th is going to be the Big 12 championship, which hopefully Baylor brings that home. And then June 3rd to June 13th, we're jumping right into regionals and super regionals. And June 15th to June 27th is going to be the College World Series. So, there's not really a guaranteed date where Will's going to be available, because during that time frame, and especially if they go all the way to the College World Series, he's going to have practices and games and rest periods necessary, and won't necessarily be able to make the travel between Houston and hopefully Omaha, Nebraska for the World Series.
No, and we completely understand that. We don't want to distract from his obligations to his team and to Baylor. it's required by law, and honestly, we're looking to support Will in that career as well. So we're not looking to really detract there. I think, the timing I have for my client right now is as early as summer, which is slightly vague. And so, I mean, what I would like to do is try to get some commitment there, especially, if it goes beyond that kind of July 1st timeframe, which goes into the off season. If we can look at having some more access there. Again, we're obviously cognizant of if it's before that, we won't be able to potentially have as much access, but we do need some level of access. First off, just kind of throughout the whole season as well, just to take a step back there, obviously we're both excited about this and it's putting a kind of a fine point on that timeline, but just kind of in general, having some access during the season would be good. I know you cut back some of the time commitment really from July 1st to January 31st. So before we kind of get an agreement on the numbers for the specific opening and stuff, I kind of want to just touch base on your thoughts on just if we can have some access to Will during the season and kind of your thoughts there.
Yeah, I spoke to Will about it and he's open to trying to make himself as available as possible during in-season. I think the way we're going to go about drafting that, and I can go ahead and take the pen and send some draft language to you, is we'll probably do a different in-season obligation of appearances versus out-of-season appearances and obligations. So out-of-season, we can go ahead and commit to obviously more in-person appearances, and particularly with the Houston location, that's really when out-of-season he'll be able to go and travel the distance to the new locations that will hopefully be opening up soon. But when we're in season, we're thinking around anywhere from 3 to 6 in-person appearances during season.
Okay.
But on that note, we're going to need to limit those in-person appearances specifically to the Waco location, just in case, he's traveling back and forth from away games, coming back to school, he's got class, he's really not going to have the time to get in a car and travel 3 hours and there and 3 hours back in those situations.
And I mean, that sounds reasonable. I need to take that back to my client. Houston is about 3 hours away. There are other locations we're looking at opening up that are a little bit closer. San Antonio, I think, is about an hour and a half. Austin, also about an hour and a half. And so we really want to look at just kind of that travel constraint around an hour. Understandably that Waco is probably the primary focus, but we would want some just a little bit broader terms on the travel. That being said, agreeing to limiting his appearances during the season in general makes complete sense. Again, we don't want to distract from it. So I can take some of the numbers back to be a couple in-person experience. What were the specific numbers? You said 3?
Around 3 to 6 is what Will mentioned, but obviously we're going to need some flexibility. And I kind of want to bring this umbrella, just overhanging fruit that's kind of tied into his in-person appearances in general, both with Waco locations coming up and also with the Houston location. It's a very unpredictable time that we're in right now. And so Will's going to need some protections to having the ability to reschedule in-person appearances, both in season, out of season, whether it's at Waco or whether it's at a new location, just in case there's any unforeseen circumstances, such as, games sometimes get rescheduled, especially if, a team comes down with COVID. We've seen how it's spread. And that situation, and the NCAA and Baylor both have COVID policy obligations that Will's going to be needing to abide by as well. So that's just kind of a back burner factor that we need to really bring into this, is understanding that, yes, Will wants to commit and show up to every in-person appearance that he agrees to. But, given just the changing times and changing obligations, there may be certain situations we can add some unforeseen force majeure language to kind of just curb the unpredictability of what could happen.
And I think that's reasonable. And even just given his commitments to the baseball team, things can change rapidly, and we're willing to put some flexibility in there. Again, I'll take the numbers back to my clients, reducing for, having 2 different categories, one out of season, one in season. Your proposals seem relatively reasonable. And now I kind of want to circle back to the Houston conversation specifically. We've discussed some in-person appearances during the on season, which likely would be Houston for this next season. And we can again look at the terms and see we can be flexible, giving you some notice, on when we need them, and then also on the cancellation. However, what I want to see is like if once it hits July 1 and Will's free, it's likely that we're still going to be in that sort of launch period for the Houston location. And so we would love to have access to Will then. If he's free and doesn't have as much obligations, we can capitalize there. And so would he be willing to, spend more time in Houston? What is does he have other constraints during that kind of summer period, which would really be the important time for that Houston location?
Yeah, mainly during the summer period, he's just going to have to keep up with workouts, practices, pitching every day, just to stay in shape, looking forward to the next season and hopefully some bigger opportunities moving forward. And so, yeah, totally how we envisioned it was, whenever the postseason ends, whether that be the end of May, if they don't make it past the conference, or whether it's going to be end of June, that's where Will's going to really be able to go ahead and make an in-person appearance. We envisioned it as a celebratory end of the season and a celebratory opening for Nightlight at a new location and making that appearance. But again, now that we're getting into these out of Waco events that we're looking at, Will's going to need to ensure that he can get some travel reimbursement for getting to and from locations, potentially staying at a hotel if he's doing an entire weekend promotion event. And then also, I know you mentioned there's kind of a overarching marketing fee, but something we were hoping to factor into it is kind of an out of Waco event fee. So if he's at a Houston location or one of the new locations that are opening up that are outside of that hour radius of Waco, having Will receive a payment of $50 an hour while he's physically making an appearance at the out of Waco store.
And so there's a couple things I want to touch on. First, you brought up that there is some uncertainty around when the season will end. We have this kind of hard July 1 date in there. And while I really want Baylor to win and go all the way through, in the event that that doesn't happen, could we build some flexibility in that Will would be available earlier? So if we do open earlier in the summer, and if that happens, again, don't want that to happen, but having some flexibility to move that date a little bit forward. So if we have to, if the opening is July or June 15th, we can have access there as opposed to just having to wait for July 1st.
I think that's something we can hopefully get done. I'm obviously going to have to double check with Will and see what his schedule is going to look like. I think some way where we can hopefully meet in the middle with that is, whatever the last day of the season is, kind of giving Will a 2-week buffer time within that to, once those, let's say the season ends June 3rd, Will's got 2 weeks after that to, go ahead and move out of his apartment, get all his stuff squared away, and then he'd be able to go ahead and travel to Houston to make that appearance. And again, as long as there's no restrictions placed by the university or just other ordinances coming into play at that time, which fingers crossed, hopefully that's all said and done with.
Absolutely. I think that sounds pretty reasonable. And then to your point about expenses, so we don't have any problem. We understand that if he's traveling, we're going to ask him to travel more. He's going to incur costs, food, hotels, potentially gas, and we're more than willing to compensate him for the reasonable cost there. And then to your point around the sort of out of town fee, if you will. And so I understand where you're coming from. He's traveling, it's more commitment, it's going to be additional time equals money. My client's concern right now is, with the retainer we proposed was $5,000. It's up to $15,000. So my client's viewing that as already a pretty significant increase there. And so as part of that increase, he's looking to, have more access to Will. I think given the additional requirements from the Houston location, he would be, the $15K retainer, he would probably be willing to pay. I would want to confirm that with him, but it seems reasonable. And I just was kind of wondering, in addition to that amount of money, what are you thinking?
In addition to the $15,000 retainer.
Yeah, correct. Yeah.
So in addition to the $15,000 retainer, we would kind of then have that $50 an hour potential out of Waco fee. And again, those are only hours where Will's going to be specifically at the out of Waco location representing himself. There's probably going to be a lot more people going to those locations who don't normally have access to Will on a day-to-day basis, being able to see him at a game. And so he's really going to be stretched thin when he's making those appearances. And, then obviously we have the bonus structures that we've kind of talked about.
Yeah.
I think if we can guarantee that $15,000 annual retainer, as well as that $50 an hour out of Waco event fee, we're going to be able to be more flexible with that bonus structure and come to an agreement that ensures that your client isn't going to be, potentially getting more added on costs as things go and move forward.
And an additional fee to travel, specifically, my concern is there's two different aspects to this. We have this immediate opening need, and then there'll be kind of it'll eventually, once that's opened, it'll be just kind of routine, and it'll be split between these different sites. And so I'm a little bit, want to see if we can differentiate there a little bit. I think my client would be willing to pay additional money to guarantee that Will is in Houston. And I think, that some sort of additional fee there would be very reasonable. I think I'm less confident that he'd be willing to, on top of the $15K, throw an additional fee across the entire contract. So if we could kind of break that down a little bit more into specifically for this term that Houston is opening, I think my client would be open to an additional fee there. However, I think we need to kind of separate those two points.
Yeah, I hear that, and I understand where you're coming from. I think a potential solution that I can take back to my client and you can take back to yours is, he'll get this out of Waco event fee for, let's say, the first 6 months that a new store location is open. Okay. That's kind of the grand opening. That's when it's going to be most hectic. That's when he's going to be doing the most work. And then, as you said, it'll probably die down a little bit thereafter. And then we kind of have some timeframes locked in to differentiate the two types of events. I can't guarantee that. Obviously, I'll take that idea back to my client, and hopefully that's kind of a middle ground that we'll be able to reach.
That sounds fairly reasonable to me. Likewise, I'm going to need to take that back to my client and make sure he's on board. But that sounds like a fairly happy middle ground. Now, the next, so just to kind of put this all together, we have this $15,000 retainer we're talking about, and this circling back to the kind of overall compensation structure. On that. And given these kind of concessions on the increased fee there, and then the potential for this increased sort of grand opening fee, if you will, new store fee, what are your thoughts around the annual bonus? Are we willing to sort of give my client some more control over just the spend on that?
For the annual retainer?
Or for the monthly bonus, sorry if I missed it.
Monthly bonus, okay, yeah. So if we can guarantee that $15,000 annual retainer, and if we can guarantee, kind of what we were just talking about, that initial 6 month out of Waco bonus, I think we're going to be a lot more flexible on the monthly bonus per post structure. And, I know you mentioned that your client kind of has an overall expenditure for what he's planning on doing for the marketing. And I know Will really is the center of nightlight marketing. There's no other athletes signed up. So he's going to be really putting himself out there during this time. Is there a potential cap that we can just kind of have in mind when we're changing around these monthly bonus structures that your client needs to be aware of?
Yeah, and so my client's sort of ballpark, kind of where he's thinking is about $30,000 a year in total, which is why, with the $15,000 retainer, we can be flexible then with a bonus. Really what my client's main concern is if we can cap the total comp at $30K, I think he'll be flexible with the number of posts that Will can do, but I do know he will want to have some control over that spend really after it goes beyond those sort of minimums. So beyond the 2 posts per social media. After that, he'd like to see just have visibility to when that money is going to kind of exit, so we can just predict his expenditures. And as part of that kind of control there, we need to have some. Well, we already agreed to having a little bit more control over the content itself, so we can go there. But just having some visibility to the spend would be great. So once Will goes beyond the 2 posts, just notifying my client would probably be sufficient, or similar terms where it's notification and then email confirmation, just so we can make sure if something goes, if he's got some cash flow stuff happening, he has at least visibility.
Yeah, that makes a lot of sense. And I'm happy to hear, that we kind of have this $30,000 budget to really work with and be flexible on where the different costs are going to come in. So I think how I'm envisioning it now and how we can take it back to both of our clients is that, we'll go ahead and keep that $15,000 annual retainer. And we'll have that travel bonus kind of structured in there as well. And then we'll be a little bit more flexible in trying to come down to a fair number for that monthly bonus structure with the amount of posts, but kind of having this overarching not to exceed language of a $30,000 annual budget. And, once we're approaching that budget, getting close, perhaps your client, reaches out to Will and says, hey, we just want to let you know, like, we're getting really close to that budget at this point in time. And that way we kind of move forward and structure how we want the post to look going further. And,
we've been focusing a lot of on the store opening, but there are, as part of that $15,000 retainer, there is a couple other terms just in the general contract that we need to go through, that would help my client justify that spend. Okay. And really the first one we were looking at is in section 4. So section 4.1 and 4.3 specifically, my client read that and then asked, in this context, we're going to spend $15,000 per year, basically guaranteed. And his question was, based on that terms, can he go eat Dunkin' Donuts across the street whenever he wants? And now we know that, it was pretty broad, and it kind of pulls in the definition of competitive products, which again, we had a fairly expansive definition. And so, but in order to really, for my client to justify that spend, we need some level of exclusivity there, or else that ambassadorship that he really is it could diminish the value, and we really wouldn't be getting what we're paying for there.
Yeah, I hear where you're coming from, and I understand. Yeah, the main reason for changing that exclusivity of products was that it was, kind of really narrowed in and focused. And I just want to curb any fears that, Will's intent isn't to, when he's in Waco, go ahead and cross the street and eat a bunch of donuts and be seen by people at Dunkin' Donuts instead of the nightlight location. Our main concern is that he travels a lot as a student athlete. If he's at an away game and he needs to drink a certain type of coffee before every game and there's not a nightlight location, he needs to be able to go ahead and grab a Starbucks or something of that nature. And as you mentioned, this is really tied in close with the competitive products definition. I think we do need to get a little bit more narrowed and focus on that competitive products definition due to the fact that Baylor may have other contracts that could be in the nature, and I'm sure they do, of prepackaged food or beverage products, with other lines of business. And if Baylor has a contract in place and this one conflicts with it based on the NIL rules, the Baylor contract is going to take precedence. So we just wanted to make sure if we can really narrow that competitive products definition, that, we're going to be able to streamline this to get compliance departments okay and get Will to sign this contract as soon as possible.
And we completely understand that perspective. He's traveling. If he's 100 miles away from nightlife, how is he expected? I can't go without coffee personally. So that's completely reasonable. I think we can cut back on that definition. Just looking at your red lines there, the one thing that I would like to add would just be a little bit more, just broaden it slightly, just in case there is some expansion in nightlife's, product line. Not crazy, not every prepackaged food, but common breakfast items sold at nightlife, just so that if we do expand into, bagels, for instance, that we're not hamstrung there on that definition.
Yeah, I understand that. And I think, if you were to go ahead and perhaps talk to Jackson and draft up some more specific language, even something I'm envisioning would be, donuts, kolaches, coffee, and other baked goods of a like nature. Yeah. Something like that would probably be reasonable. We're just going to have to double check and probably take that definition to the Baylor compliance department just to make sure we get that okay. That way we don't structure, anything else in the contract around that. And so I think we're on the same page as far as that competitive products definition, which is great. So kind of moving back to solve that issue with the exclusive use of products, we both agree that Will shouldn't be constrained from either drinking a coffee while he's away, or if he's in the dining hall, rush to get to practice and needs to grab a dining hall coffee or bagel, that he's allowed to do that as well. So I think a potential solution that we would be able to do is, when Will is not acting as a student athlete and doing his obligations as a student athlete, such as being on campus, being at away games, running to class and that nature. And when he's near a Waco location, then if he's not in any other situation as his student athlete obligation rises, then he can go ahead and stick to that exclusive use of Waco products, or excuse me, Nightlight products, as long as, there's a location like the Waco one nearby.
I think we could put some sort of geographical or reasonable sort of standard there, so he's not limited in what he can do. So that all sounds good. I'll take your definition of revised definition back to my client. We'll wordsmith a little bit. We can figure that out. As long as we get that 4.1 in there at some level, again, as long as we can put a reasonableness standard in there. And then just kind of moving on to the 4.3, my client's perspective is that, his just kind of having the coffee, talking to his friends about the coffee and donuts, it's being an ambassador, really, being in, is kind of part of that $15,000 retainer. And so I was just wondering, do you have any specific issues with the wording in there? There's something I know is important to my client. Is there something we can do to come to a middle ground there?
Yeah, so just so you understand the rationale behind our strike there, the language in here is really about promoting the sale, promoting the use of the products. And how we see this contract, he is an endorser, not an employee of Nightlight. And so while he's happy to endorse the product to the best of his ability and tell people about it and tell them how much he loves a Nightlight donut, he cannot try and promote the sale of the products and, kind of have that contingent factor being brought into this. And so this language was kind of inherently like using him to do that. And so if we were to, at least strike the promote the sale and use language, and maybe in that latter part, just to endorse the relationship between endorser and company, that would be more of a middle ground that would be acceptable to us. But we just want to make sure we're staying in that endorser ballpark versus an employee.
And it was not our expectation that he's a sales representative. It's more of a, like you're getting at it. He's a brand ambassador. And so we're happy to revise that and make it clearer that he is an ambassador and an endorser, not a sales associate.
Great, we appreciate that. And I think one other point that you were kind of mentioning, earlier that we wanted to hit on, and that's just kind of a good check for us too, is that assignment provision.
Correct.
And so we were just kind of seeing how, Jackson is obviously expanding locations. He's got the Houston location coming up, and Will's really just enjoyed meeting Jackson and is really looking forward to grow that specific relationship further down the line. And so is Jackson planning on staying on board for these further locations coming up, or does he have different plans?
So, Jackson has no plans currently to leave Nightlight. Now, while it's, Jackson and Will's relationship is great. Ultimately, this agreement is between Will and Nightlight, who is my client. And so looking at that assignment provision, my main concern is it puts a lot of emphasis on Jackson himself and my shareholders, who ultimately is whose value I'm trying to increase. If he leaves and then I lose the value for the shareholders of this endorsement deal, and like you said, Will is he's our brand ambassador in this kind of field. He's our one guy. We're putting a lot of emphasis on Will, and we're basically tying Will to Jackson. And that's just a lot of risk for my client, that if Jackson decides to do something different, something happens, gets hit by a bus, and then suddenly we lose all of the value of this contract. And we are looking to expand, and so we need to keep tight control over our assets. And this endorsement agreement is an asset for my client, and so that was something that we need to look at and see how we can kind of protect Nightlight itself. Now, and just on that note, what is the concern that Will has with Jackson? Is it a brand identity sort of thing? Is it what is this kind of thinking there?
Yeah, I think right now the relationship between Jackson and Will, as we've mentioned throughout this conversation, they have really the same tie and values that Nightlight's trying to represent. And Will really wants to make sure that the Nightlight brand isn't going to somehow change if Jackson unfortunately decides to go another route. And his main concern is, we're going to have some big corporate big shot who really wants to come in and restructure everything. And if that's someone that completely has different values than Will, he's not going to be able to endorse that brand to the best of his abilities in that situation. And so I understand, this endorsement agreement is going to be between Nightlight and Will themselves. And so Jackson, has the flexibility to see what other opportunities come up in the future, getting back to that unpredictability of things. And so, I think while Will obviously wants to work with Jackson, mainly something we can potentially add in is, if someone besides Jackson comes in, we want to go ahead and have a 30-day trial run with whoever that new individual is that's going to be entering the relationship, for Will to go ahead and get to know me, make sure that the brand isn't going to completely change. And, at the end of that 30-day trial run, if the relationship's great, we keep moving forward. But at the end of that 30-day trial run, if Will's feeling like everything's really changing and this isn't the agreement and the relationship he entered into, he would need a termination right in that event.
And I think in general, I mean, we are very cautious about our brand as well. It's a lot of what has made us successful and will help us to continue to expand. So I think in general, that sounds reasonable. The specific terms, in order to do something like that, I would want to really line out, how that decision is made. I would be worried about giving Will then kind of sole discretion to just terminate the agreement if he just doesn't like somebody. We need to really structure that it's kind of good faith mutual agreement. There's a material change in the branding, not just I miss my friend Jackson in a sense. But I can take that idea back to my client, propose some wording, and then follow up with you via email. I also just noticed we're running fairly low on time now. So is there anything, and I want to just kind of circle back to, we've got some framework on the compensation structure. There are some additional specifics that we'll need to further discuss before I can really guarantee my client will accept the $15,000 retainer. Some of them really are just 10.4, the use of inventory for commercial use. We don't need to go into specifics now, 3.2. 3.2 for the use of commercial, and then 10.4 for the use of inventory. And so just a couple of things to note there that I will be following up to kind of hammer out a couple more details there.
That sounds great. And, I think as long as, potential inventory and commercial products are going to be kind of still in this Texas local region, that shouldn't be an issue to hammer out those details, contingent on the fact that it really solidifies that $15,000 annual retainer fee, which is crucial for my client in this contract moving forward. But, as you mentioned, I think we've covered a lot of ground here today. And so a quick revision to just kind of make sure we're both on the same page of what needs to be done and what we're able to agree on moving forward is probably going to be the best way to spend these last few minutes.
Absolutely.
So I think in terms, go ahead.
Okay. So looking at what we've kind of gone through, we talked about the monthly bonus and the retainer in general. We spent a lot of time there. Some of the key points I think we found is my client has a $30,000 kind of maximum spend. We can be fairly flexible on the details of the bonus. But in order to do that, we would need some control over the content, which we've agreed to, specifics there, as well as control and visibility to any time the spend is getting to a certain level, which again, we've come to a reasonable kind of idea there, and now we just need to hammer out the details. Then from the retainer, we were looking at $15,000 contingent on kind of a lot of stuff that we need to keep going through. We've talked about his availability during the on season, if you will, and we've agreed to 3 to 6 days, which I'll take back to my client. We've also agreed to agreed in concept to the idea of some sort of store opening additional fee where, especially for the Houston location, there may be an additional hourly charge, and I'll, take that back to my client and try to get some details there. We also agreed to the definition of competitive products. We're going to do some wordsmithing there, but in general, we're going to narrow that, which will allow some more exclusivity for Will and Nightlife Donuts, and we'll throw a more reasonableness standard in there so he's not going without coffee before a game. And then we're going to reword 4.3 slightly to kind of make it clear that he is not a sales associate. And then lastly, we kind of touched on the assignment provision, and we're talking about sort of a 30-day if there is a change of control and Jackson is no longer there, we're looking at sort of some sort of 30-day trial period, which again, I need to take back to my client, but we'll come to terms on how that's determined and, how we can keep this relationship going.
Yeah, that all sounds great. I think you touched on everything. Just one clarifying point, when we hit on that 3 to 6 days of the in-season appearances, we just want to make sure that's specific to the Waco location only. But thanks again for meeting me today. We covered a lot of ground.
Thank you as well. And I'll follow up with my client on the specific to Waco, but we can deal with the details there.
Great.
Yeah.
Good morning, Bess.
Good morning, Zach. How are you?
I'm doing well. I just spoke with Jackson a couple days ago, and he reiterated to me his excitement for this deal. He's really excited to have Will on as a promoter of this company, not only for his accomplishments on the field, which we know he's such a talented baseball player with MLB prospects, but for his values off the field. We know there's a little bit of a family connection, and we know what they do is aligns with our values, which is so important to us. So we're really excited to continue working together and get a little closer to closing. How are you?
Yeah, that excitement is mutual, I assure you. And I know that we only have a little bit of time today. I've spoken to Will recently too, after having gone through everything. So I know you've gotten our redlined version of that contract. So I didn't know if you wanted to list out maybe some priorities for us to cover in our limited time today.
Yes. So my priorities, one of the things is terms relating to possible expansion. I know that sort of relates to the recent development, so that's something we definitely want to prioritize. We wanted to talk a little bit about the terms regarding the length of the term and termination. We wanted to hit on the requirements under the agreement that Will would be required to perform. We wanted to touch on compensation. I know that'll probably come up with the new development on your end with YouTube. And as time permits, there's some other miscellaneous provisions that we're going to try to hit on. Does that align with a lot of the things that you were considering?
Yes, I think that is perfect. So
Okay.
I'm ready to jump in whenever you are.
Awesome. Yeah, that'd be great. So if we could start with that possible expansion, there's a few terms I'd like to touch on.
All right.
I'm going to reference the red line and try to give out sections as I go along. If at any point you're confused, please let me know.
Absolutely.
I want to make sure we're always on the same page. So to start with, if we could go to section 7.2, this is on page 4 of the red line. One of the things that you guys had included in this red line version was a limit to the amount of time that Will would be required to travel. And in this case, it was 1 hour. Could you talk a little bit about the reasoning behind that 1 hour limit?
Yeah, absolutely. I don't have much justification other than that is a provision that Will explicitly asked for.
Okay.
When we went through the red line together, I think it goes kind of hand in hand with not wanting to overcommit himself, having a significant amount of obligation both with school and baseball. So that was something that just came straight from him.
No, and that makes sense. So what I'm hearing is it's more or less a commitment thing. He's worried that when we go beyond that time, it might conflict with other things. Okay, that makes sense. Well, with our expansion coming about in the Houston area, we are hoping that we could get a little bit of flexibility here. I know other locations we're considering expansion would be Dallas and Austin, so they'd be a little outside that 1 hour time frame. Houston would be closer to the 3 hour time frame.
Right.
And in considering those things, do you think it's possible maybe that we could expand this travel restriction to within the state of Texas?
Right. After seeing that email chain, I know that that's going to be a big priority with that Houston opportunity coming to the forefront.
Sure.
You said exactly what my concern was that obviously we laid out an hour in the beginning and that Houston trip is more of 3 hour one way. I definitely think we can be flexible, especially noting that, you know, this new opening is something that's going to be really beneficial to the brand as a whole.
Absolutely.
I think though that for starters, I noticed that the summer opening was something that was brought up.
Yes.
This isn't something we need to negotiate just because this is part of the NIL law, but if Baylor is to go to the College World Series, that's going to fit around that last week, 2 weeks of June. So that is something just to take into consideration. But
Absolutely.
I'm thinking that I kind of want to limit that number of trips and then give him some additional compensation for the trip in addition to the reimbursement, maybe a flat fee for each time that he has to travel to Houston.
Okay. I think that we could talk about that in the scope of compensation, and that's definitely understandable. It is time that he's going to be spending doing it, and it goes into the appearances a little bit. But I think we'd be amenable to limiting the number of times that he'd be doing it.
Yeah,
Ideally, for this year, we wouldn't be looking for that many in season, other than the fact that for this opening that would occur over summer.
right.
So I think we could come to a mutual agreement about limiting the amount of time in season, and in general, and then in the scope of compensation, when we get to that, talking about how we could fit that in.
Awesome. That sounds great.
Okay, so with that, I think we can sort of just tentatively agree that Texas is probably the main scope we're looking at with this sort of extra compensation and limitations. Does that sound about right?
I might want to qualify it to, let's explicitly say, the Houston, Dallas, or Austin locations. And if
Okay.
we get to a point where there's another location outside of that, we can revisit that. But yeah, I
That'd
think
be
to those three is appropriate.
Okay, yeah, and we'd be happy with those limitations. Like I said, going into this, we were sort of expecting Dallas and Austin,
Right.
but with these expansions, there is a possibility that maybe other things can come up. Maybe San Antonio. I don't think that would be outside of the scope of an hour, or an hour and a half.
Right.
But that would be something we could address with them. So I think we're in a good spot there. We'll keep it limited to those locations that we expect those expansions. Awesome. I'm so glad we could come to an agreement there. It's good to get the ball rolling.
Exactly. That's great. Yeah.
So while we're in this section 7, if we could go back up now to section 7.1, and sort of already we're hitting on this, especially when it comes to this year, we're going to need to try to expand that, one, for the opening, and two, a little bit more generally. When it comes to limiting it to July to January, it is going to be during his season that we're not going to be able to capitalize on his brand recognition. And that's also the time that his name is going to be worth the most. He's going to be in the papers after he throws a shutout or he has a great game. So we're hoping we'll be able to see a little bit of flexibility there. But if you could talk a little bit about any other concerns you have with that limitation, I'd be happy to hear.
Yeah, I think we're definitely flexible to expand a little bit of that time commitment into this season. I completely understand your perspective of exactly what you said. He's hot during this season. That's when the people are going to want to see him. And that's when you would reap the most benefits from his presence. Absolutely. I do think, and this is something we could kind of delve into that language offline at a later point, but as far as maybe setting up some specific content filming days that are outside of this season, so much of that social media marketing can be done on the front end, kind of save that for later on and publish as needed. So as long as we get that licensing through Baylor for him wearing a uniform, I thought of a funny video, and we'll get into the YouTube too, but getting him back there with an apron on, see Will Rigney make nightlight donuts, that's obviously something that could be filmed outside of the season, saved and published for that later point. I think it would be hilarious. So content outside of this season, but I think we can definitely be flexible for a few appearances during the season, just, qualifying what those hours are and keeping that a little more limited.
Right. Yeah, I think that would work well. And I think having that social media scheduled in advance would help, and it'd be beneficial to both of us. That way, it wouldn't create any conflict on his end. So I think we're definitely in accordance with each other there. And with limiting the amount of days and the amount of hours, I think that we do have a little bit of wiggle room there. I don't think we could go necessarily to the numbers of 7 days, 3 days, just because, as you mentioned, there is a lot of effort that goes into making these things. So we are going to need a little bit more expansive than that. But I think it sounds like there is a little bit of flexibility on your end as well. So we could work out the numbers more exactly.
I think the bigger concern is definitely keeping that limit during the season. We've got a little bit more flexibility outside of the season. Absolutely.
And that's great. As long as we're able to capitalize to some extent during the season, that was really Jackson's main concern, because he knows Will's going to be crushing it, and we definitely want to take advantage of it.
We hope so. I've got my Baylor green on today in his honor, so love it.
Okay, we're making great pace. So the next thing, when it comes to possible expansion, was dealing with section 3.1, the grant of endorsement rights. I noticed that you guys had struck out and its affiliates. Could you talk a little bit about the reasoning behind that?
Yeah, I think, and this speaks to, I think, to the definitions of affiliate and control of company. I
Okay.
think that the bigger focus on this is that we prefer for the language to be changed to company and company subsidiaries, as
Okay.
opposed to, we're okay with encompassing the different locations of Nightlight. What we aren't okay with is if there becomes another piece of control, that this includes businesses that Will was not initially agreeing to partner with.
Right. Okay. And I understand that completely. So if I'm hearing this correctly, it's really just an issue if it's expanding beyond Nightlight. It's not necessarily issues with Nightlight itself. And I think that aligns really well with what we were hoping to get at. I agree with you. The language of affiliate is pretty broad as it's currently written. So why don't we do this? If we can limit affiliate to some language along the lines of in connection with the company or similar business of Nightlight, so it just gets to those brand affiliates of Nightlight. Do you think you'd be comfortable maybe reinstating the affiliate provision in 3.1?
Yeah, I think so. I think that the broader point that we're getting at, as long as it is Nightlight in any branches of Nightlight, but no company outside of Nightlight as a whole.
Okay, and we're definitely amenable to that, and that's what Jackson had wanted here. And I think this will help when it comes to the expansion of Houston, because that is one of his concerns. There are definitely Rigney fans throughout the state of Texas, not just Waco. So we want to be able to have that brand recognition in those other cities.
Throughout the world, 105,000 of them.
Yes, exactly. Okay. The only other thing that I really wanted to hit on with when it comes to possible expansion is the right of assignment in section 20. And I know there was some pretty significant changes here. This is on page 11 of the red line. So could you just talk through a little bit of the changes?
Absolutely. So really the way this was written in the initial contract, the meaning of that being that there could be assignment, there didn't have to be notification, and there didn't have to be permission for that on Will's part. And that was really where we just drew a line and said, we can't agree to this. Okay. What we changed it to was changing control of company to be, as long as Jackson's in control, we're okay. Anything outside of that, not okay. And something we looked at from reviewing those organizational documents was that we saw that there was a new class of stock of that Series Seed preferred. Yes. Which typically, in my experience, lends to the opportunity for venture capitalism. Okay. We didn't have a share register though. So there was no way to see exactly who had ownership, just that there were these different categories of stock. So as far as the language, I think we can be flexible. This really leans to kind of the point I just made back in 3.1. But as long as Jackson is a CEO or senior executive officer, we're okay. We just want to make sure he's involved in the day-to-day operations, because that's who Will has the relationship with.
Right. And that's completely understandable. I know that a lot of the reason why, outside of, Will's baseball skills, and we think he aligns really well with the morals, is the connection that is between Jackson and Will. So we definitely don't want to do anything to upset that. So I think that one way that we could address this then possibly is to have a notice provision in advance that provides Will something, some sort of understanding of what's going on. And as so long as Jackson is related to those executive positions or in a position of control, then maybe we would be okay without approval. Because I know that's a big sticking point when it comes to other people who might be looking, let's say Nightlight takes off and there's no prospects of this right now. As far as Jackson has made it to us, he's focused on expanding and just keep building this brand.
Right.
But we do want to consider long-term marketability, because we do think after Will helps with our marketing, this could really blow up, and we'd love for Will to continue to be a part of that.
Absolutely. I will say, I'm not sure I'm comfortable with just notice. I think just from the client directive, I think at least if Jackson is no longer a CEO, like I said, like that language is flexible, senior executive officer, but that Will gets a termination right the day that he is no longer in one of those positions.
Okay. That sounds reasonable. I'm going to take that back to Jackson. This was one of the points that he did want me to bring up, like I said, in the scope of possible expansion. So I'm going to run that possibility by him. Like I said, he was concerned a little bit about the marketability in the future, even if he was going to stick around with having an approval. But I think it's reasonable to want that, considering their relationship. So I'm going to bring that back with him. If that's okay,
we'll put a pin in that one for now.
Cool. That'd be great. Okay. I think we covered all the main provisions with possible expansion that I wanted to get to. I know there will be some sort of minor changes throughout in our markup back to you when it comes to that, but we hit on all the big issues. So I'm happy to move on to term and termination, if that's all right with you.
Perfect. Let's keep it rolling.
Awesome. I appreciate that. We're making such great headway. So if I could, I'd like to start in section 10.1.
Okay.
And this is just going to the amount of the term. I know when we originally sent our proposal, we had provided something regarding his NCAA eligibility, and that does conflict with NIL. We didn't realize that that could create a conflict if he elects to go to the draft early. So we're really glad that you had limited to participation in the program. But in reconsidering the basics, since we were out of compliance, Jackson and I spoken, he thought it might be a good idea to present to you a possibility of a term of 1 year. And there's a couple reasons why. The first thing is this does ensure, just like your provision, that we stay in compliance with any NIL rules, because let's say he elects at the end of this year, we're still within that 1 year term provision. And second, it's connected with the scholarship, which is what they do with the school tax purposes. So it would align with his connection to the baseball program. And then the third thing, and I think this is where Will might really like it, is it gives us the opportunity in the future, so long as we include a renewal provision in section 9, to be able to maybe renegotiate his compensation. So let's say, as we expect, he crushes it. We're generating a ton of revenue thanks to him. And we see a great value in keeping him along, and we want to give him more. We want to incentivize his fair market value more. I think that we would be definitely able to do that. So in considering that, do you think it'd be possible to maybe do a 1 year term here?
I will say that being outside of what was in this initial contract that he and I spoke through, that's something I'd need to take to him. I will say my reservation with that, like you said, we changed the language not to change the term, but really to align with that Senate bill statute or the NIL statute in Texas. Mm-hmm. So my issue with the 1 year is that takes away any guarantee from him. You know, let's say that this is roughly a $60,000 contract in total over those potentially 3 years right now. Sure. You know, that really makes that down to a third of that based on it only being a 1 year. And you mentioned section 9, which you probably obviously saw that we kind of struck the whole concept. But the issue with that too is that I see that provision is a little bit one-sided. Okay. And that it encumbers him outside the term of this contract, and that he would have to give Nightlight a right of first refusal, even if they just offered to renew the contract. So all of that together, I think, is a lot to digest. And I don't know we'll be able to get through all of that today. But in that this is a new proposal for y'all of the 1 year term, I'll do the same thing that you did with the assignment, and I can write it down and take it to him, and we can talk through that a little bit further.
I appreciate that. And I apologize for springing this on you. We didn't realize at the outset with our original proposal that we weren't in NIL compliance. So in rethinking it, that's just what Jackson thought might be beneficial for the both of us. But I definitely understand your concern. And I hear you when it comes to the one-sidedness of the right of first refusal. So in talking about those provisions, we'd be happy to sort of scrap that right of first refusal and just be looking at the renewal. And that way it would really be sort of for having the option for that renewal option to talk about compensation. Maybe we work out those minor details and keep this process going. So I would really appreciate you taking that back to Will, because I think it could be beneficial for both of us. Okay. And then while we're in section 10, I would like to talk a little bit about the morality clauses. I know you guys had made a number of changes. Yes. The sort of C through G range. Could you talk me through your reasoning there a little bit?
Right. So obviously, I think morality clauses in general, I think we both know are pretty standard for this industry, for really any industry relating to a public figure. You think about a Tiger Woods situation and you start to lose your breath a little bit because nobody wants to be stuck in the middle of that. So, you know, we can be flexible here. We understand that there are certain provisions laid out for the benefit of both parties. If something were to happen, the relationship would need to be terminated. Right. A big issue I have, and the reason the whole thing was scratched, is with 10G. I just don't know that it's fair to hold him to a standard that encompasses all family members as well.
Cool.
I really would like for this contract, and Will too said the same thing, just for it to be focused on his behavior and not that of anyone else.
Okay. And that's understandable. So what I'm hearing is that Will's looking for morality provisions that are focused on his action.
Exactly. So we can be flexible with the others and kind of flesh through that language. I think we could bring some of that back in. We really just qualified D through E, but
right.
Or really D through F if we're looking at the original numbering, lettering. But if we could keep G scratched, I think I would be satisfied with that.
Okay. And I think we're amenable to that. That's completely understandable. And we have the utmost confidence that this won't be an issue.
Right.
And that's really why we want to work with Will, and we're comfortable with his family and that he aligns with our morals.
Right.
So
you got to plan the divorce when you plan the marriage. So you know, I totally understand.
Yes. So we'd be happy to scrap G, and then we would just look to reinstate some of the language in those other provisions that you mentioned, just to make it a little closer to market. Like I said, our moral values are so important to us in being kind, being exceptional. So we just want to make sure all those actions would align with it. And like you said, the market has done that. There was that UCLA student who, using profanity on a video had been covered under a clause.
Right.
So if we can just get a little closer to that, I think we'd be in a really good spot.
Yeah. I think we can agree to revisit that language as long as G is stricken or remains stricken.
That sounds great. We're definitely happy to do that.
Awesome.
Okay.
Moving right along.
We are. It's great. One of the things you had mentioned was Will wanting to only be held accountable for his actions. And that, like I said, I think that's completely understandable. And that sort of takes us to an issue that we had when it came to indemnification. So if we could go to that section.
That's
13.1. Yes,
okay.
That's correct. And really, the only issue that we noticed that a lot of it was just made reciprocal. So we're all right with that. But any use of the products by a third party was something that was a little concerning to us. So did you have any reasoning for that you wanted to talk about?
So I think you're actually talking about 13.2.
Oh, yes, for that specific.
Okay.
Yes, I apologize.
No, you're okay. I just was making sure
yes.
We're on the same page. So really the way I read that was that Will would be on the hook if we have, you remember the famous McDonald's coffee situation. Woman burns her tongue on the coffee, everybody gets sued, makes a ton of money. Will is just a third-party service provider in this agreement. He, in that way, if we're looking at this, say his face is on one of those boxes of Nightlight donuts, someone gets food poisoning, he also gets sued in that way too. We just really want to make sure that he does not assume risk just because he is sued by a customer.
Okay. And I understand that, especially having the hot coffee case as a good placeholder. That makes sense.
Such a classic.
It is. I think that I'll have to take this back to Jackson a little bit. Like I said, this was something he was hesitant about, of only wanting to be responsible for things that we did. So I think there is going to be a little pushback of having this extension to third parties when we are providing an essentially reciprocal provision to you that doesn't include actions of third parties. But I'm happy to take that back to him, especially considering the precedent that has occurred in this area.
Right.
So I'll take that back to him and talk a little bit about that reasoning, because I think, like I said, I think that is pretty fair.
Awesome.
And then to go back to termination, sorry to jump around. I was just thinking about the actions of one individual.
Right.
We did want to talk a little bit about the termination provisions that you added that provide more options for Will. So specifically, I'm looking at 10.3D on page 8.
Okay. I appreciate that numerical point because I'm looking around.
I know there's a lot going on, so I want to make sure we're centered on the same thing.
Right, 10.3D.
Yes. So could you talk a little bit about the reasoning behind the inclusion of that provision?
Absolutely. So you can appreciate how new all of this NIL business is. Just a few years ago, college athletes had no way to monetize their personal brand. And now here we are having them become influencers. So because of how new everything is, and really more importantly, because there's no federal law, everything about this right now is being piecemealed through state law. We just want to make sure that if it comes to our attention that this contract violates any of that law or any of the rules, that it's null and void, and that he's not at risk of losing a scholarship or eligibility because of a mistake on someone's part.
Right. And I hear you, definitely understand the amount of change, that this is just an ever evolving area. So we definitely want to make sure compliance is at our top priority. We don't want to have to put Will at risk of anything. He's worked so hard to get to this point. So we definitely want to make sure we're always helping him there. I guess the only thing maybe then to keep this provision in the way it is maybe add a possible good faith negotiation requirement. Like you said, this is an ever-changing area, so we don't really want to lose the contract for compliance issues that we can see coming. So if we could have like a mandatory renegotiation that is to come after this, or some sort of grace period, I think that would provide Jackson a lot of comfortability.
Yeah, I agree. And I think that really aligns with state law, and that usually there's a 10-day cure period.
Right.
So if that's something that we want to write in, I think we're perfectly okay with that.
Yeah, I think a cure period would work really well. So I'll mark down a cure period, and we can talk specifically about what those other states that you had sort of mentioned, what they outlined for those specifics, and we can nail down that language there. But I think we made a lot of good headway there. So I appreciate it.
I agree. I hate to be pushy, but I think it might be about time to flip to compensation, just in the interest of time, to make sure that that's something we get to today.
Right, absolutely. I'm more than happy to turn to that. So do you want to start with the retainer provisions? Would that be the best place? Because I know there's a lot of moving parts when it comes to the monthly bonuses, reasonable expenses during the month, but it might be easiest just to start there.
Perfect.
I know you're at 15, we were at 5. Do you want to talk a little bit about how you came up with that number?
Yeah, so I think in general speaking, the way that advertising is moving is to this social media influencer marketing. And in lieu of a traditional advertising agency, typically for this type of paid media management or brand management, you'd really be looking at a minimum of about $3,000 a month. So if we're kind of calculating that on an annual basis, that's all the way up to 36. So we figured that if we had that retainer around 15 in conjunction with the monthly payments from the social media post, that still would be a deal for Nightlight, but also would ensure that, if especially getting into those negotiations about the monthly, we figured we might have some pushback there. So keeping that ensuring no matter what, we have the 15 a year, and that includes all of those appearances as well, especially now that we've added in, the traveling too. I know that he's getting compensated for that, and that's something that we can talk about later on too, but that's something we could also have tied into that annual as well. That's really just ensuring he's being compensated for the work that he's doing.
No, that's completely understandable. And I think the easiest way might be at this point to sort of tie it into this original retainer, just because we do have those other moving parts and we don't want to complicate it too much. But I just want to make sure what I'm hearing. So he's looking for ideally about $3,000 a month. Is that correct? Would that's what he's hoping for?
Well, $3,000 a month would be $36,000 a year. So as far as what we built into the retainer, that's obviously significantly less than that. That was just, I was using as an example of what a traditional advertising agency would charge for that brand management. So in total with per year with this contract, if you have the 15 and then you're adding in the monthly, I envision that being around 25 to 30 a year, depending on kind of what we nail down as far as that monthly schedule.
Sure. And that makes sense. And that's definitely understandable. And I'm glad you were looking at this sort of traditional agency approaches. I know this is such a changing area, so I'm glad to have that and be able to work through it. I think a 15 number for retainer would be a little high. And we do want to make sure there is an incentive as far as the posts go to put out good content, keep putting out content. So I think there would be a little more wiggle room maybe with the amount per post on that end. But I think we can come up from that 5,000 number. One thing that I might suggest, and this is something, like I said, this is something that's new in this area, but we looked through and we reviewed the provisions among the other states, and we had noticed for NIL stuff that 10 of 27 states had this provision that required compensation, NIL compensation, to be commensurate with fair market value. So we were interested in hearing what you might, if you might be interested in having maybe one of those agencies in those locations providing what they see as a fair market value here, and then maybe going off that number. Would that be something you're interested in?
Yeah, I will say we've done some research on our end as well. And just in the general scope of sports marketing influencers, people that are getting paid for these sponsorships, per post, you're looking at 200 to 5,000. And I wanted to give, I know that's a really broad spectrum. And I know I'm kind of switching gears to post, but that kind of ties into the retainer as well. I think looking at how many followers Will has, I feel like that's not something that's really clear as far as the value of that. So I just wanted to touch on, as far as college level baseball players, he doesn't really even fit into the league of those. You're looking at most of those players, even top draft picks, sometimes only have 2,000 followers. Some of the most popular baseball players are closer to 50. Him all the way with 105 is more in, I really, just to give a good comparison, Heisman prospect category. Matt Corral over at Ole Miss was an early Heisman favorite, and I think will be in the first round draft pick this year for the NFL. He's only at 93. You've got Bryce Young, who did win the Heisman, at 194. So this is kind of more in the area that we're looking at, and definitely would be traditionally on the top end of that per post. You know, if the top of that's 5,000 and we're only asking to charge 150 per post, the way I see it is that we've kind of tied in more of that value into that annual retainer.
Right. And that makes sense. I appreciate you having all those examples. Those are great examples.
It just makes it a little bit easier to justify, I think.
And that's fair. And we definitely know how much value Will can provide to us, and we don't want to undercut it. And that's why I had sort of suggested that fair market value assessment.
I think if you want to share that with us, I think we'll be willing to look into that. Did you have a counter for that 15?
Sure. So I think we are working with budget constraints. This is the first year we are putting money into marketing, and this is the first year we're doing NIL stuff. So we are working with a pretty tight budget here. So I just wanted to preface it with that. I think one thing that Jackson would be comfortable with would maybe be in the 8 range of retainer, with a little flexibility in post. And like I said, a little bit with the renewal, this is something that we could work with when it comes to the future, when we have those renewal option negotiations. And I know you're at that higher end when it comes to the post and when it comes to the retainer. So there were a few creative options that I had to maybe generate money outside of these two things. So I just wanted to run them by you.
Okay.
I know you'll have to take them back because they haven't been considered.
Right.
But one thing, to the extent we don't think we can reach an agreement because of our budget constraints solely through retainer and post, the one thing we thought of was possibly having Will choose his favorite donut in the store. We'll name it the Rigney donut. We'll give it a little bit of an upcharge, so let's say 20, 25 cents. And then monthly, we'll provide what that upcharge was to Will as a royalty. So that's another way, he can be promoting his donut, sending people to come in, and really based on that interaction, he'll be able to get more expansion there. The other thing was allowing for designated autograph sessions at the Nightlight stores. And with that, we could provide some catering to help generate people to come in, and he could charge for those autograph sessions. So we're just trying to think of different creative ways. Like I said, we are in a pretty constrained budget, but if Will would be interested in those to sort of help maybe meet us in the middle with those other numbers.
So it's funny that you said that, because we also on our end were thinking as far as creative solutions. And I figured that something that would be brought up would be, being that this is so new for Nightlight, not having done advertising in the past. A question that might come up would be, how do we know that we're getting what we pay for? We want to make sure that the money we're spending, if I was Jackson, I would be thinking, I'm spending all this money. How do I know that that's correlating to sales? So something that's pretty common in this industry, and again, not meaning to blindside you with this, just talking creative solutions, I think that this could be one as well. There's a popular platform called Our Style, which is more for fashion influencers, but I think that we could utilize here. It creates a commissionable link. So anytime that a follower went through this, we would have the data to see that he brought this customer to nightlight, whether that be through online, there is online ordering I saw being utilized on the website. So that would be a way to do it there. Another way would be a discount code. You might see this online with media influencers, but he comes on and says, hey, use my code WILL10 for, 10% off at checkout or whatever. And that would be a way. That's a discounted way, but a way to follow that. Our style would not be discounted. It would just be a way to use the data analytics and track how many customers he's bringing, to track that market and profitability kind of together. And so I think that could be something that's talked about as well. Basically him getting a percentage of profitability. Maybe if we're lowering that retainer, I think that would be easier for him to stomach, knowing that he has this retainer, but assuming he's successful with bringing in customers, he would be reaping the benefits of his work.
Absolutely. I really appreciate you coming up with those solutions and bringing those to our attention. That was definitely one of the concerns on our end, is how do we connect, making sure his engagement, creating revenue for us. And that was one of the reasons why I brought in that donut example, just because
I think that's perfect. Those same kind of ideas, I think, are what creative solutions that if Jackson as a business owner has those concerns that I anticipated, that could be a way to ease those a little bit.
Yes. So I'm not familiar with the R Style platform, so I'll have to bring that up. I'll look into it a little bit and then talk about Jackson with it. But I think he'll definitely be excited for something like that. And with that clear understanding of how much he's generating for our brand, I think he'd be happy to work out something, at least profitability percentage, or something along those lines.
Right.
And one thing you had mentioned earlier that might go into percentage of profitability in the event that, maybe given the difference between the dynamics of apparel and what we're doing with our style, is possibly just being able to provide Will with some of our equity, because we are a corporation. So we have some non-voting stock that we might be able to consider in the event that doesn't work out.
I don't even think that that's a possibility that he considered. So I think that's definitely something we can bring to the table.
Okay, that would be great.
Obviously, think that's not cash on hand, but looking to his future, assuming the success of the company, that might be something that he's interested in.
Absolutely. So I think we have a lot of creative solutions there. I'd be comfortable with you going back to Will and telling him, as far as retainer goes, we're probably in the 8 range. And when it comes to posts, we can talk about those numbers a little more, but it might be best if we talk about those creative solutions first and then come back with those, if that's all right with you.
Right. Just to clarify, and if you're not able to disclose your position on that, I understand. Is 8 your bottom line? Is there any wiggle room on that retainer? I say your, and by you, I mean Jackson, but from what your conversations with him, is he flexible at all on that? I think at least we were kind of looking at we threw out 15. I think the minimum we could do might be 10. So I just wanted to see kind of any flexibility existed there.
I think the flexibility would come down to whether or not there could be a little bit of flexibility on your end when it comes to the post. Like I said, we are working with sort of just a general budget. So to the extent we're taking out our budget from the post area or the reasonable expenses a month, I think we could work with the retainer. But I think 8,000 puts us in a safe position to talk about posts with a little bit more flexibility, if that makes sense.
Okay, well, I think that's a great point to jump in. If you want to talk a little bit about what your goals were with that post language and what you wanted to see from him or not see from him based on it.
So were you referencing then Exhibit C? Would that be the main portion, or just really Exhibit A, B, C?
Yeah, I guess A and C together. We wanted to touch on the YouTube as well. So I think that both of those are this is a good point to talk about both of those.
Okay, and I guess I'll start with C, because this was one of the concerns that we had. We noticed you added, and for any additional posts, endorser may publish. Like I said, we are working with a budget, so if possible, we wanted to see if you'd be open to possibly putting a cap on the amount of posts that there would be per month. This just really provides us more transparency into how much we're going to have to cover. Like I said, we don't want to overcommit ourselves with those constraints. So do you think maybe a cap would work?
I totally understand those concerns. And I think we can discuss a cap. A caveat just from the marketing perspective that I did want to mention there is that, we have right now in the language of A, the 2 posts per month is the minimum.
Yes.
I will say, I'm not sure how much traction just 2 posts a month from him is going to bring. I
Right.
totally understand the cap, and we are in no way trying to bankrupt your company with the compensation on the post part. But I
Yes.
think that is something to think about, as far as the point of this is to bring in more revenue, bring in more traction, more customers, more followers. And I'm not sure how much the 2 posts alone is going to do, but we definitely can discuss a cap. I think also if Jackson was amenable to the provision about having a percentage of the revenue, I
Okay.
just want to make sure, all of the compensation, this whole economics package ties in together.
Right.
And so, like you said before, there's so many moving parts. I know we're going to have to take a lot of these pieces back, but I think if the cap is introduced, we really want to make sure that that revenue percentage is a piece of the compensation.
I think that would make sense, and that's definitely understandable. We definitely want to try to make the most of engagement, like you're referencing. So we're
Right.
happy to try to be flexible with that. And maybe you talk to Will about what he thinks. Maybe we could look at his use thus far up to this point and sort of use that as a starting point for what we need here to base
Okay.
that cap. And I think as far as I know you guys have this sort of schedule based on the amount of followers that he has throughout the year.
Right.
I will say that might be a little bit of a difficult point for us. Like going back to that transparency of, there's really no way for us to predict. And like with the YouTube, this sort of just happened with him putting out a video, and who knows how many followers he's going to grow from something like that. So maybe if we could tie that back, I could bring this back to Jackson as being tied to profitability. So maybe more on that end than necessarily have based on the followers, just so that way there's a connection between the revenue we're bringing in. And that way we're comfortable with saying, all right, since we have this extra revenue, we can give a little bit more here.
Right.
Would that be something you'd be amenable to?
I will say I don't think I'm quite comfortable agreeing to scratch the increase in payment per post based on followers at all. And the reason I say that is because that's really an industry standard with the influencer marketing. It typically a cost per thousands of followers formula is what's followed, which is why we kind of wrote that out there. I'll kind of just walk you through for an example, but if you're looking at that table at 125,000 followers, that payment per post is $175. That equates to $1.40 per 1,000 followers of exposure for Nightlight. So that really is a fantastic deal as far as advertising goes. I know that this is all really new. And again, the bottom line is really important. So as far as a package deal, I know that the payment per post might be a concern. I think that we can address that, but I don't think Will would be comfortable having this total exhibit or provision nixed from the contract.
No, and that's understandable. So what I'm hearing is with the increase in post, this is based on a metric that we're trying to stay connected with and just stay with market. Okay, that's fair and that's reasonable. I think what I'd like to do is take that consideration back to Jackson so he could further evaluate maybe what his top of the line is, because with a high retainer, which is I know what Will is looking for, I don't think that we could be at the 250, 225 mark, sort of irrespective of these followers. If it wasn't connected with revenue, we would need that extra budget to be able to make sure we're within our constraints. So I'm happy to take that back to him with sort of getting a better understanding of what our cap is here when it comes to the engagement based on what the influencers are usually otherwise getting.
Right. Let me ask you one question. I know we only have a little bit of time left today. So something that we might want to be able to take back is, does Jackson have an idea of what he wants his total cost for this deal per year to be? That might make it easier for us on the back end before we meet again to be able to adjust those numbers and make sure all of those provisions of compensation are accounted for.
Absolutely. I know there are some provisions we probably won't have the chance to touch on with our time that go to competitor products and what exactly is going to come. So I would just preface this by saying these are all tentative based on how those end up working out, but maybe in the 28 range, I think he'd be comfortable with. And to the extent that doesn't co-align, I know you guys were closer to 36. I think we could try to use those other creative methods to bridge that gap there.
I think so too. I think so too. And like you said, all of these different parts play into it. I think some things that we've discussed today, just to kind of recap, to
Yes.
take back to both of our clients,
Mhm.
really kind of breaking down that compensation package into annual retainer, price
Absolutely.
per post, and then also the potential topping 10%, whatever we want to say, of revenue to Will as
Right.
far as compensation for that profitability. So there's really three components to that.
Mhm.
I think obviously, like you said, that's something that Jackson needs to be aware of, and maybe with all of that we've talked about today, you can kind of explain to him the justifications for those and where everything comes into play.
Absolutely. I'm more than happy to do that. I think we came up with a lot of great solutions for the monetary issue. I know that's a big part for Will. He definitely wants to get his fair market value, and that's what we want. There
Right.
were a couple provisions we didn't have the chance to get to that I just want to
Right.
get your attention to, so we can be prepared for that when you see the markup for next
Right.
time. So the definition of competitive products, like I said, this sort of goes back to Will's requirements in section 4. The
Right.
approval of posts, we noticed a pretty big change there that we wanted to talk about.
Right.
IP rights, we didn't have the chance to touch on this, but I'm sure that'll be something that's pretty large. And then a little bit of discussion about arbitration in the future. I don't think that'll be a big sticking point, but just to sort of make sure we're on the same page there. Those will be
YouTube as well. We really want to bring that back into that social media definition. And I think that's included in kind of everything we touched on today.
Absolutely. Well, it was a pleasure working with you.
Awesome, Zach. Thank you.
Thank you.